Chahowski,
Yes.
you're supposed to be here in person. Why are you not here?
My letter tells me it's Zoom on 6/22.
The hearing opens with a rocky start as the judge questions why the defendant didn't appear in person. The defendant insists he received a letter telling him to join via Zoom. However, the court quickly clarifies that a second notice was sent, updating the appearance format to in-person due to a violation hearing. Probation attempted to contact him, but with no success. The judge expresses concern over the lack of updated contact info. The defendant's communication issues already place him in a bad position. It's clear he didn't follow up or verify changes. This simple failure to appear has now become a bigger issue. In court, miscommunication doesn't equal immunity, and missing a date is still considered a violation.
That's what my letter tells me.
I'm looking at the notice that was sent out.
All right, I
So
have
there
it
was
right,
so,
I have it right here in front of me.
Mr. Chahowski,
Yes.
your original letter that was sent out on March 23rd said that it was to be via Zoom. Another letter was sent out on May 13th because instead of a review, it was going to be a violation. And that violation was changed to be a hearing in court. And Mr. Morano tried to reach out to you regarding this and was unsuccessful. So did you not have the right contact information?
So I did not have any good contact for him. I have emailed him and he has failed to appear for appointments on May 23rd and June the 7th as well. So I've had no contact with Mr. Krause for.
When's the last time you had contact with him?
The last time we had contact was May the 9th.
So Mr. Chahowski, how did you think probation was supposed to go? Did you think that you just checked in when you felt like it?
No, not at all. I understand my civic responsibility. That's why I'm with you. That's why I'm with you here today.
As the hearing continues, the judge highlights that the updated letter clearly indicated a courtroom appearance. The probation officer confirms that several attempts were made to contact the defendant. The defendant tries to explain that his email was locked after moving. He claims it's the reason he never got the updated notice. The judge and viewers are puzzled, since when is an email tied to a physical address? Still, the real issue isn't technology, it's personal responsibility. The judge wants to know why a simple phone call wasn't made. It's a fair question that the defendant dodges. Changing contact info without notifying probation is a problem. It's not the move, it's the silence that matters.
Your Honor?
Yes.
I'm in the process of moving and I've changed locations. And since I moved locations, my email has been locked.
The defendant reveals that he also changed phone numbers. The court asks the obvious, why not update probation? The defendant shifts gears and begins speaking about his father's passing. He states that the loss has impacted him deeply and he's been dealing with the estate. While the judge expresses sympathy, the legal expectation remains the same. Grief is understandable, but it doesn't cancel obligations. The judge reminds him that notifying probation of changes is required before a violation, not after. The defendant offers to provide new contact details now. Unfortunately, that's already too late to undo the missed appointment. It's a valuable reminder that even during hardship, legal duties must be maintained.
So I haven't been able to get a hold of my probation officer through my email. And I'm dealing with that right now.
Well, is your phone number the same?
No, I got a different phone number.
The judge makes it clear he needs to see the defendant in person to proceed. An in-person court date is set for 1 week later. The defendant immediately resists, saying he can't drive due to his suspended license. He questions why his physical presence is necessary and fears being arrested. He references a past incident where he spent over 40 days in jail. The judge listens but remains steady. A failure to appear today doesn't help the case. The judge calmly explains that if jail was the goal, a warrant would have been issued already. Instead, this is an opportunity to show up and explain. The judge is offering grace, but only if it's accepted.
So, Mr. Chahowski, when you're on probation, when you change address and phone number, don't you think it would be a good idea to make sure your probation officer knows that?
Well, I think it's a good idea, but you got to understand I've been dealing with my father's death that I caused. And I've been dealing with cleaning out the house, and I've been trying to find an apartment. Yes, I understand that, and I do understand my civic responsibility. I do, this is the first contact that I've gotten at this location, and I'm happy to give my phone number and my address to my probation.
The defendant's tone shifts and becomes defensive. He insists he's worried and unclear about why an in-person appearance is necessary. The judge documents that the defendant acknowledged today's date and still failed to appear in person. After a brief pause, the judge reiterates that failure to comply with probation is the core issue here. When asked again about showing up in person, the defendant flatly refuses. The judge warns him that refusing to appear will lead to consequences. He emphasizes that showing up is not optional. The court gives him 1 week to comply before further action. This is a last warning, not a threat.
Mr. Chowski, I need to see you in person, so I will adjourn this 1 week. So it will be set again a week from today. At the same
Why do you
time,
want to see me in person? I don't know if I can go down there. I'm not sure if I can do that. I don't have a driver's license. I cannot drive. I can't be going any place. You know, my license is restricted. So I'm not really sure whether or not, and I'm not sure the reason you want me down there. For what reason? To put me in handcuffs and put me in another 44 days of jail?
The defendant tries to argue that he shouldn't have to appear because of past negative experiences. He recalls being jailed previously and fears a repeat outcome. He insists he doesn't trust the court and believes attending will lead to immediate jail. The judge explains calmly that he is not out to punish without reason. If the judge wanted to issue a bench warrant, it would have already happened. The defendant's refusal is based on fear, not fact. The judge gives him one final chance to clarify his side in a respectful tone. He reminds the courtroom that cooperation helps, while defiance only worsens outcomes. The door to resolution is still open, barely.
So, Mr. Chowski, this will be real simple. I want to make sure you can hear me okay, and I'm a little concerned at your tone.
Well, I'm a little concerned about what you're stating. I'm a little concerned. You want me down there for what? For what reason?
Okay, so I will note today that Mr. Chowski was aware that he was supposed to be here today. Mr. Chowski has indicated that, oh, hang on a second. Mr. Chowski, can you hear me? Mr. Chowski, can you hear me?
Yes, I can, officer, or honor.
All right, this is real simple. I'm indicating to you right now that it is the order of this court that you present yourself to the court a week from today. Are you telling me?
I'm not going, Your Honor, I'm not going to court. I cannot get there, all right?
The judge emphasizes that he hasn't ruled out any alternatives to jail. He acknowledges the defendant may be dealing with mental health struggles. Instead of reacting harshly, the judge offers patience and a pause. He invites the defendant to contact probation and begin correcting violations. There's recognition that the defendant may be overwhelmed, but the judge won't ignore noncompliance. A week is granted to take corrective steps. The court doesn't rush to judgment but expects accountability. Respectful communication is still the path forward. The judge assures the defendant that this isn't a punishment. It's an opportunity. The only thing required is action and sincerity.
The probation officer knows my, and he can adhere to that. I cannot go to court. Last time I went to court, they put me in handcuffs and put me in jail for 44 days. I'm not going.
Was that Mr. Chowski?
The judge continues his explanation with fairness. He reminds the defendant that this isn't about special rules, it's about equal treatment. Everyone with a violation must appear in person, and this case is no different. The defendant assumes he's being singled out, but the judge denies that claim. The court requires the same effort from everyone. The defendant's behavior, though fueled by fear, borders on disrespect. The judge reminds him that virtual court is still official, and proper conduct is expected. Any inappropriate outbursts can lead to further penalties. Still, the judge remains calm, allowing space for the defendant to understand the gravity of the moment. Time is ticking to take the next step.
Or was that a different court?
That was Macomb County, but I know why you want me to go down there to put me in handcuffs. What the hell did Your Honor, what did I do? What did I do?
Mr. Chahowski, I'm
Yeah.
happy to explain it to you. You have failed to appear for probation appointments.
No, I did not. No, I did not. I told you why I did it.
Boy, that escalated quickly. I mean, that really got out of hand fast.
Listen to me.
All right, Mr. Chahowski, I'm not gonna tolerate you speaking to the court in that tone. You failed to appear today. You've indicated, no, Mr. Chahowski, I've hit you on mute. I have nothing more than I need to hear from you. I've indicated to you that you have 1 week from today to appear at the court. If you're not here a week from today, then you're absolutely right. You will find yourself in a jail cell a week from today. If you show up a week from today and perhaps explain to me what's going on with you in a manner that's respectful, he's not listening.
No.
That's unfortunate.
As the hearing nears its end, the judge checks once more if the defendant understands the expectations. The defendant finally speaks, describing how he contracted COVID while in jail. He shares that his father also became sick and passed away after his release. His emotion is clear, and the story is tragic. He questions whether jail is appropriate under current health concerns. The judge responds that many safety measures are already in place. Still, the defendant insists they're not enough. While his grief is understood, it doesn't excuse avoiding court. The judge again encourages accountability. It's not about punishment. It's about resolution and respect.
Okay. So, Mr. Chahowski, I'm going to adjourn this violation for 1 week. I'm going to adjourn this violation and it's going to be in person. Now, during that week, I am inviting you to reach out to your probation officer because nothing is etched in stone. Your last experience where you went in person to court, you did 30 days, okay? Now, you are not in compliance with probation, but that doesn't mean that I automatically go to the consequence of a jail sentence. Because I know, Mr. Chahowski, that with you, there are also, there are many different challenges, including some mental health challenges that you try to work through. And I know that your rage at the court right now and inappropriate behavior today is a byproduct of fear and a byproduct I know there to be a significant mental health challenge. So I am willing to wait and pause and give you a week to respectfully reach out to probation, understand why you're in violation, try to see if you can correct those violations and come up with a plan outside of the jail setting. I am at least willing, even now, to consider those opportunities. I have not made a snap judgment about you, Mr. Chahowski. I have not come to the conclusion that you are unredeemable or that you need to do 93 days in jail. I simply ask that you not make a snap judgment about me or my probation department. Everybody here is required, wait, I will unmute you in a second. Everybody here is required to meet certain standards. You are here for criminal behavior that needs to be addressed. I know when your mouth is open, sir, that you're not listening to me. I know when your mouth is open, I will unmute you and you can make some comments in a second. All right? But I know when your mouth is open, you're not hearing me. You made an assumption. You've made an assumption that I'm trying to figure out a way to put you in jail. All right? I'm simply trying to get you to come here as anybody else who has a violation. Everybody else who has a violation is here today in person. Everybody else. I don't have a special set of rules for Daniel Chahowski. You have to meet the same set of rules as everybody else.
The judge gives one final statement: show up in a week or face a bench warrant. The defendant doubles down, saying he will contact probation but refuses to appear in person. The judge has now made everything crystal clear. Not showing up will trigger legal action. Despite multiple warnings and chances, the defendant ends the hearing with a refusal. The judge closes the case, noting all statements for the record. He had tried to help, but effort must be mutual. The defendant's fear may be real, but refusal to act responsibly won't help. Court isn't about feelings, it's about facts. And the facts are not in his favor.